I'm here today with a very special guest, Beverly McLachlin, retired Chief Justice of the Canadian Supreme Court. This is an opportunity I honestly thought that I would never have in my whole lifetime. So I am beyond excited and so grateful that she's taken the time to speak with us today. Beverly McLachlin was the Chief Justice of the Supreme Court of Canada from 2000 until 2017. She's not only the first woman to ever hold that position, she's the longest-serving Chief Justice in the history of Canada. She was born in small-town Alberta, not too far from where I am in Calgary right now, studied philosophy and law at the University of Alberta, called to the bar in 1969. After teaching at the University of British Columbia, she was appointed judge in 1981. Since that time, she's served on several levels of courts: the County Court of Vancouver, the Court of Appeal and Supreme Court of British Columbia, and of course, the Supreme Court of Canada. In 2018, she became a Companion of the Order of Canada, the highest honor within that order. She has dozens of honorary degrees from around the world. She's now retired from the Supreme Court, or as she calls it, transitioned. And not only has she done everything that she's done in her lifetime, she's written 2 books. One is a work of fiction called Full Disclosure, and the other an autobiographical account of her life called Truth Be Told. I have a copy of it here. I've taken just the cover off the book because my copy is so full of stickies and Post-it notes, it's embarrassing to hold it up. It's a great read. And today we're going to talk about both her journey to the Supreme Court, some of the passages from her book, and where she's headed next. So welcome, Beverly.
Lovely to be here. Thanks, Chris.
I'm so glad you're here. 2 things before we dive into some questions. I want to make it clear to everyone listening that I'm only calling you Beverly because I have permission to do so, because you have many other titles throughout your lifetime, and I don't want it to appear as if I'm in any way disrespectful. So thank you for this opportunity to call you Beverly, but I'm just wondering, for everyone out there, our audience is quite broad. How does one respectfully address a Supreme Court judge?
Well, as I often say, I'm just an ordinary person now. I don't have any particular titles. And so Beverly is great. People, though, I find a lot of people who knew me when I was a judge, they just cannot do it. And so they call me something like chief or judge, and that's fine too. These are honorifics. They don't indicate that I really am a judge, but anymore. But it goes with the role I've played for so many years.
Well, thank you. I mean, I think part of your appeal to so many of us is your approachability. And even though I am feeling very respectful of you, I'm also so appreciative of your realness. So thank you for that. The second thing I want to do before we dive into some questions is I want to share a little story with you, which I have never told you before, about how you saved my life a little bit a few years ago. Beverly and I first met up. Yeah, it's true. Beverly and I first met 7 or 8 years ago, and we were both invited to speak at the same medical malpractice conference. It was all lawyers, and the focus was medical malpractice. I made a presentation in the morning, and you, of course, were the keynote speaker in the afternoon. I got up and did my thing, and over lunch, before you got up to speak, I was sitting with a group of lawyers, all men, all plaintiff lawyers, and somehow the topic of conversation turned to the next big trend in medical malpractice. And I said, I think the next big trend will be infection control. And the response from the table was fast and furious. It's like, oh, the standard of care this, and the damage is that, and the causation here, and the inability to prove, and the damages. This is never, ever, ever going to happen. And one of them at one point even said, like, look at her. She's like a little tiny minnow in the midst of a great big group of whales. And there was like a big laugh all around the table. So oh, no. I just politely excused myself from that mess because I thought, this is not going to go anyplace good anytime soon. And then you got up to speak, and I don't recall if someone asked you about trends in malpractice or whether you just, this was part of your presentation, but you said, I think the next big trend in malpractice is going to be infection control. And you went on to say that at that time, U.S. hospitals were already withholding payment to hospitals who they felt had high rates of preventable transmission of infections. And so I got some nice looks and a couple of apologies after that. And I just wanted to share that story with you because you unknowingly, but perfectly on that day, came to my rescue. So thank you for that.
Glad to be of service.
Yes, thank you. I'd like to talk about your career. A Supreme Court of Canada judgment that you took part in surrounding a malpractice case. Some stories about from your latest book and whatever else happens to come up. First of all, I've just finished reading your autobiography, Truth Be Told, for the second time, and congratulations on a really great read. I just enjoyed it so much, and for those of you who haven't read it, don't miss it. It's just an amazing story from a somewhat ordinary life to a pretty darn stupendous life in my eyes. But the very first passage that made me stop and think for a few minutes came on page 77. You're talking about your first year of university. You're taking your Bachelor of Arts, and you describe yourself like this. And I'm reading from the book. I was diligent, never missing a class. I was studious, laboring 6 evenings a week and Sunday afternoons at the small desk. And I was socially awkward, a country girl flailing in a sea of urbane sophisticates. No one took particular notice of me. No one particularly liked me. No one particularly hated me. I was, in the true sense of the word, unattractive, incapable of attracting good or bad, a solitary soul lost in a whirling social cosmos. That phrase, I just stopped because first I want to thank you for your honesty and sharing that, because I think so many of us have felt that way at different times in our life. And I particularly remember feeling that way in my first year of university, coming from a small town and going away. But I was struck throughout the book how many times you talked about that struggle and those feelings that you were really fighting with. So could you share with us, what was it, or is it the trait within you that propelled you forward despite that? And how do we get some of it? Because I would think we could all use a little bit of that.
I really don't know the answer to that question. I do know that I don't give up easily, and I always felt, without articulating it, that if I just pushed forward, everything would come all right. And I think one of the problems growing up is that our society sort of expects us to find our niche very, very early when we're still children. I was barely 18 when I went to university, and I had very little experience with the world. I was unworldly in the true sense, and there was no way I could figure out what my life was going to be like, or what I wanted to be, or what trajectory I might follow. And this is, I think, a very common thing for young people. And I think what you have to remember, and this is now being verified, there's a book out called Range by an author named Epstein, that often it's quite natural not to know what you want to do, and you should just try a lot of different things, and as Joseph Campbell put it, follow your bliss. And so that is what got me through. I thought, I'll keep trying different things and see what will work out. And that can be a huge benefit, both in actually ending up finding out where you fit and what you can do and what you will like doing, but also all the things you look at along the way as you're struggling through this uncertainty contribute to your breadth of knowledge, and you start being able to make connections between disciplines and so on. And so I think that period of uncertainty, difficult as it was, and to some extent I've been uncertain for much of my life, a very prolonged period, but it really made me branch out. I wanted to learn about the world. I wanted to know more about literature, music, society, and so I thought I'll just keep learning, and that's what kept me going through.
Well, good for you. And congratulations on that level of grit and resilience, for lack of other words, and maybe curiosity to explore the world. So thanks for that. That's a good answer. In your book, you also talk a lot about accessibility to law and refer to the Canadian Charter of Rights and Freedoms, which I loved. I was born in the United States, and I don't have a ton of Canadian history in my background, so I learned a lot from your book. Because I think many of us, on the subject of accessibility, many of us have a sense that the law, and particularly the Supreme Court, is out there. It's untouchable. It's so far away. It doesn't affect me. It doesn't have anything to do with me. And I learned so much from you about how you are our Chief Justice. You belong to all of us, and the courts represent us. You speak a lot about the idea of equality being central to the fairness of the law, that all people should be treated equally, and that the inequalities should be tolerated in order to help the less well off. I love that statement, I have to tell you. And it with its purpose is to not make life harder to people without resources, to give us all access. Mm-hmm. How do you think first of all, thanks for that great thought, and that, to me, that gave me a sense of accessibility to me. But how do you think we're doing right now in these tough times in the areas of accessibility to justice for all? How are we doing?
It's been very tough. I've been working on a number of committees and with attorney generals and other people who are saying, what are we going to do to cope with this difficult time and build a better justice system going out? Our courts and many tribunals were already somewhat backlogged, and some extremely backlogged before COVID hit. And then COVID hit, and lawyers' doors shut, court houses' doors shut. People could not go to the usual physical places they would go for hearings or filing documents or any of the things one does. And so, of course, we still don't know the amount of it. I can't seem to find statistics, but we must surmise that courts that were already backlogged are going to have greater backlogs because cases have had to be put off. And that's not good for access to justice. So that's the bad part of the picture. But the good part of the picture is that there's been a great deal of innovation in the justice system as people try to cope with the really serious, critical, urgent matters like child protection or like bail hearings or like very situations that simply have to be dealt with in the criminal courts or whatever. So what has happened is that people have said, okay, we can deal with this particular emergency by a video platform like Zoom or by a telephone, and we can do things in a different way that will allow us to do what we need to do to see that justice is done. E-filing wasn't common, I think, in Canadian courts, most of them, prior to the pandemic. But a lot of courts said, well, you can send your documents over by online. No reason why you can't. And you can't come to the courthouse and talk to somebody over the register across the counter, but you can do that. And legal advice and legal help similarly are often now being given virtually. So I think that what we're seeing is that we need to bring our justice system into the 21st century. We need to bring it into the world of internet and digital electronic communications. We need to use the tools we have for better scheduling. We need to move into a world where we can collect data on how well we're really doing. I mean, you wouldn't run a corporation now without daily data. How's our productivity? How's our sales? How's our whatever? And we've never done any of that in the courts. And I do believe that the COVID may be a lesson a learning experience for us so that we can see, A, we need to do things differently, and B, we can improve our justice system and bring better access to justice going out of this. What I'm afraid of is that as things improve, we'll forget these lessons and we'll slide back to the old ways, because it is a conservative profession, and people like doing things the old ways, and they're very good. The problem was that, and is that, it's just not tenable anymore in our world. We're just operating with a 19th century justice system that depends on paper and in-person hearings for everything, and we're in a 21st century world, so we need to get with it.
Good advice right there. Just get with it. I've certainly talked to lawyers across the country in the last few months, and there's a lot of echoing of what you just said. We didn't think this would ever work, but it does work, and in some ways it's better. So this, getting with it might be one of the things that sticks out of this whole messy COVID thing that we've got. I want to talk to you a little bit about some of the Supreme Court decisions that you were involved in, but our audience includes doctors and nurses and lawyers and members of the general public. And could you first share with us just a general overview of how it is that a case ends up in the Supreme Court from start to finish? And from once it reached your hands, first learning about the case, hearing the facts, discussing the issues, deciding and writing the judgment. Just a quick primer 101 on the Supreme Court of Canada.
Well, very quickly, there's a trial, and of course the case starts long before then with discoveries and so on, but there's trial and a trial judgment, then there's an appeal and an appeal judgment, and then the losing party can apply for leave to appeal to the Supreme Court of Canada, which is granted if there is a legal question of importance that should be settled. And if leave is granted, then it's scheduled for hearings, and factums and documents, of course, are prepared. The judges read them. We have the hearing. The court leaves the hearing, has a meeting, deliberates. Somebody writes a judgment, maybe more than one, and when everyone has signed on to one judgment or another or written their own, then the case goes out from the Supreme Court of Canada.
So that little 3-minute description you gave us, though, probably takes years, 7, 8, 9, 10, 12
years. It often does, yeah, unfortunately, yeah. When I was sworn in as a justice of the Supreme Court, the treasurer of the Law Society of British Columbia made a quip that everyone smiled at, but he said I had made it through the court system faster than most cases, and sadly that's true.
Yeah, funny but not funny, right? Yeah. So thanks for that. I mean, I didn't really understand that again till I read your book or till I got involved in the medical legal world. You were involved in some incredibly influential Supreme Court decisions. Is there one in particular that you're proud of or that sticks out in your mind as memorable?
Oh, no, I can never give one. There were so many memorable ones. I was on the court from 1989 to 2017, end of 2017, almost 18. So that's a very long stretch of time, and almost, I think of it in 3 decades. I write about it in terms of 3 decades. And so there were many, many cases that were very important. Areas that stand out are the charter work. The charter was brought into effect in 1982. I became a judge at trial level in 1981. And so my career paralleled the development of the charter and all the big issues under the charter, how it would be interpreted, and all the particular issues that flowed from that. I think equality has been a huge issue of importance to me, and I wrote many decisions on it. Indigenous rights, the court during the time I was on it basically had to create a body of legal jurisprudence on on Indigenous rights and that kind of thing. And so this was fascinating and very important work. The secession reference will always stand out in my mind because that was a real challenge in a difficult time, and sometimes courts do have to find themselves, whether they want to or not, in politically laden situations, and it was not apparent how we were going to answer the questions: could a province secede unilaterally without worsening the political situation? But in the end, we dug down. We did a lot of jurisprudential thinking, and about the nature of our confederation and how it's founded on fundamental principles of equality and democracy and respect for minorities and rule of law, and said those principles have to guide the answer to a question, so that if there was a clear result on a clear question in a referendum, a decision by the people that they no longer wanted to be part of the country, then that would the federal government would have to sit down and negotiate. The Canadian way is not the way of war; it's the way of compromise, negotiation, respect for rights, and that judgment was very important, and it remains very important in international law. And then there's a whole raft of social issues like the right to medical assistance in dying, like same-sex and other gender rights. And all of this is fascinating work.
No kidding. Very fascinating. And many of those decisions have really stood the test of time and societal change. Mm-hmm. And congratulations on that. And I love how you mentioned there that you had to tune your thinking to jurisprudent thinking, or I'm not sure exactly how you said it, for this one particular decision. Your influence as a judge went from making decisions regarding a single person or a single life to all the way to affecting the way Canadian law is administered. Mm-hmm. How did your thinking and your mental process have to shift or change, or did it, in that process of thinking small to thinking as big as it gets? And not that ever being a judge is thinking small. I don't want to offend in that sense, but affecting one life to affecting many lives.
Well, yeah, I think you think the same way. Judges think the same way, regardless whether they're dealing with a big constitutional question or a dispute between two parties about a renovation project. You apply you try to find the facts, and you apply the law, and you come out. In appellate work, it's all about fine-tuning the law. So the basic process is the same, but what differs is the sense of responsibility, that you always feel a sense of responsibility, but you know that if you're developing doctrine that's going to affect the future of the country or many hundreds and thousands of lives, there comes a special responsibility. And on these difficult moral issues like the right to assistance in dying, it's a real responsibility, because you can't, you know, and you must not just plug in your own predilection or view. You have to really dig deep into the jurisprudence and into the values on which the country is founded and come up with the right answer for the country and for Canadians as a whole. And when you're faced with these very large issues that will impact so broadly, you do a lot of that digging.
I bet you do. I can't even imagine. And I like you said, it's the weight of the responsibility shifts, knowing, how many people you're going to affect and for what period of time. There are a lot of things that I'd like to talk to you today, but this podcast is called Inside Medical Malpractice, and the focus is about malpractice. And something I just want to share with everyone is when I first approached Beverly and asked if she'd take part in the podcast, she said, I don't really think I know much about malpractice, and maybe I shouldn't have argued with the Chief Justice, but I did. I said, I beg to differ. I think you know quite a bit. In fact, I've heard a tremendous amount about the Snell versus Farrell Supreme Court decision from 1990
Yes,
dozens of times at medical legal conferences that I've attended. And we're going to talk a little bit about that today, because whether or not many of us know it, this case has worked its way into the fabric of medical malpractice law. And still today, I still hear about this decision. So what I'll do first of all is just share a few facts about the case, and then I'll turn it over to you to talk a little bit further about it. And I hope I get this right. The case the case is called Snell versus Farrell, a Supreme Court of Canada case from 1990. It's from New Brunswick, and the case involves an ophthalmologist, Dr. Farrell, who performed cataract surgery on a 70-year-old woman, Mrs. Snell. During the surgery, Dr. Farrell noticed a little bit of bleeding in the right eye as he was performing the procedure, which was thought to be the pinprick of a needle, which caused a little bleeding. The physician stopped the operation and waited 30 minutes to confirm that the bleeding wasn't serious or continued, and then proceeded. Following surgery, it was found that there was some blood in the vitreous fluid, which is that white gooey gel that's found on the inside of the eyeball, the largest chamber of the eyeball. And it obscured the vision in her right eye and didn't allow the physician to examine the optic nerve because it was bloody fluid. Several months later, when the blood cleared and Mrs. Snell should have been able to see again, it was discovered that her optic nerve was damaged and she was now blind in that eye. Mrs. Snell sued Dr. Farrell for both negligence and battery, and from what I understand, went to trial, went to Court of Appeal, and landed in the Supreme Court, and really became about deciding whether proof of causation in a malpractice case lies with the plaintiff. And I hope I'm correct. Can you tell us more on that, how and why this decision came to be, and why it was such a precedent-setting case?
Well, I really avoid commenting on particular cases because the reasons speak for themselves. And I've always believed that judges shouldn't go around talking about what they really meant or what made them decide that. But I can say that I think the area of causation is extremely difficult in medical malpractice, also in many other situations, like what caused the building to collapse or whatever. But in medical malpractice suits, proving causation, which normally the onus is on plaintiff, it can be very difficult, because whenever you're in an area of high expertise, complexity, it's very difficult sometimes for a plaintiff to say what actually caused the problem, whatever it is. And they know that something bad happened. There are probably many, many factors going into that. And the law we've inherited, says you've got, the onus is on you to prove not only that you've been hurt, but that this person you sued was the cause of that. So one finds endless cases and variations on causation, but there's a general idea that if you establish a range of that whatever happened was within the expertise of the person you're suing, there can be slight shifts, evidentiary shifts, and so on, where at a certain point that person has to answer or explain. So there are a lot of doctrines around this. Snell versus Farrell is one of those cases. But I think that the problem of causation is a very difficult one for the law to grapple with. And we know it's a difficult one even in our society. Things happen and people say this was the cause, that was the cause. And so the law has done its very best, I think, and judges have done their best in cases like Snell and Farrell to keep to the basic principles, but to make it possible, practical, for people to recover when someone when they've been injured in their view, as a result of someone's misconduct. At a certain point, the other person has to explain or something like that. So this is why I guess it's so much talked about. It is a difficult area.
And in this particular case, the Supreme Court upheld the trial judge's decision. I believe that the doctor was negligent, and even though causation wasn't directly linked to the pinprick to the blindness, there was no other obvious or explanation for what had happened. So the Supreme Court upheld the decision. Yeah. A question about that. The final paragraph of this judgment reads, and I'm not sure if you wrote this judgment. I'm not sure. You may recall it.
I can't even remember at this point. I do remember the case, though.
I didn't know how to find that out. It's not anywhere on the judgment itself. But the final paragraph of this judgment reads, while this court does not ordinarily make findings of fact, this course is fully justified in this case. I'm of the opinion that the trial judge either made the necessary finding or would have, but for error of law. Can you talk just a wee bit about error of law and how this guided or justified the Supreme Court decision?
Well, I think that refers to the fact that when you talk about error of law, the judge you're talking about made a mistake in how they applied the law, and that mistake then may have contributed to other mistakes. So I think that's what the idea is. Yeah.
I understand. Okay. I found a quote from you which I really loved, which again, this was in a Reader's Digest article called Great Canadian Quotes, which included one by you. And I know. I found it's a great quote, and it really kind of addresses to what you just talked about. It says, like every other human institutional endeavor, justice is an ongoing process. It is never done, never fully achieved. Each decade, each year, each month, indeed, each new day brings new challenges. And I just, again, appreciated that. That just gave me a different understanding of the process of law, not just the institution of law, but the process of law. And I think what you just talked about, the era of law and how things change and stand societal test. And it seems that this is a decision that has stood the test of time.
Yeah, the great thing about the law is that it admits a flexibility. It allows for social, technical, and other changes to be recognized as the law develops. There's a statute law, of course, which parliamentarians and legislatures may change, but judges change the law subtly when new facts arise, and they have to take old principles and apply them to those new facts. And so the law grows, and as Viscount Sankey said, it's a living tree capable of growth and expansion within its natural limits. That doesn't mean that judges are just going to have the license to do whatever they want. They don't. But these incremental growths, this method of incremental growth that tied up with our doctrine of precedent, and each case is a new case idea, allows the law to adjust to changes in society. And I think that it is very much a process, and each case is part of that process.
Yeah, interesting. And I think good for all of us to know that we're not going to be held to laws from, sometimes we're held to laws from hundreds of years ago because some of the basics are the basics, but it's good to hear that things change as life changes, and we all change. Because podcast listeners include a wide variety of audience, but we're really quite focused on lawyers and healthcare providers, but we also have public listening. I'd love to hear your answer to this question for each of these audiences. In your view, what is the most valuable thing that you would like lawyers to know about our legal system? Big question.
Well, I think the lawyers know this, I think, and so to say, I'd like them to know. It may sound a bit strange, but I think they know that it's a system that exists to serve the public, and that it's more than just a way of making money or even winning a particular case. It's a profession of service. And the law, more broadly, its institutions are institutions of service. They exist not just to perpetuate themselves, they exist to serve the public.
Very well said, beautifully said. As you know, my background is in healthcare, and there's a lot of differences between healthcare and law, but that being of service is something that these two professions have in common, and I've always appreciated that, lawyers who really understand that concept. And what about for healthcare providers? What would you like them to really know and understand about our Canadian legal system?
About the legal system, that it's designed to give fair outcomes. And I know it may seem a thing of mystery to many medical practitioners or others who find themselves involved in legal concepts and legal cases, giving evidence before a judge, may be sued because they've done something allegedly wrong. And they must feel frustration at how slow the process sometimes is, and they I've heard they may complain they don't understand it or understand why things are done. But I think that they should remember that this is a process which has been proved over the years to produce just results. And fairness is fairness to both parties is absolutely essential. It lies at the heart of the justice system, and they should also understand, I think, that every society has to have ideally a justice system that the people respect, a place where people can go to get their disputes resolved. And this is a way of keeping our society peaceful. If people lose faith in the law, in the justice system, they take the law into their own hands. So if I were a doctor, I'd rather have an angry patient sue me in court, go through that fair process, than run the risk that that patient might get really upset and do something outside the law. That's the kind of measure. I think I'd like to say that to people who find themselves caught up in the justice system and say, why me? It's not working right. It's slow. It is working right in the long run, and it's essential to the peaceful resolution of disputes and our security.
That was very beautifully said. And I think I certainly know a lot of healthcare providers who think that the legal system is just a thorn in their side mostly, and don't really have the understanding of what you just described about the fairness to all parties and the rights of people to, have access to damages if they're injured, and the whole process that has to happen to make that decision. So thank you. Would your answer change if I said, what do you want the general public to know about Canadian legal system?
No, I think it would be the same thing, but I would like the general public to feel, and I'm not sure they do as much as I would like, that the system is there for them. That's why I'm so keen on access to justice. I want every woman and man, even a child, to have the sense that the system belongs to them and that it's there to serve them, and that they can get justice at an affordable and within a reasonable time period. And we're working on that. That's a work in progress.
Yes, it is a work in process, but what a worthy cause, worthy goal to have. I just want to ask you one kind of, a fun question. In your career as a Supreme Court judge, you talk quite a bit about the many, many, many people that you got to meet and the events that you attended, prime ministers and attorney generals and leaders from around the world. Just a tiny little bit of dignitary dishing. Who's the favorite person that you ever met and why?
I'm not going to answer that. First of all, I'd have to give it a lot of thought. But to say someone is a favorite person, I mean, there are people I love, there are people I know and admire.
Could you say someone memorable? Could you talk about someone memorable? Maybe not favorite. That's a bad word, perhaps. But
well, I think meeting the Queen, sitting at dinner with her, and our conversation, that was very memorable. But I've had one of the great pleasures of my life has been that I've been able to meet so many interesting people, not necessarily the famous or the rich or whatever, but just really interesting people. Even as a trial judge, someone who has no claim to fame or particular wealth would impress me as being such an interesting person. And I've had the privilege of sharing insights with different people. Sometimes people hold very high responsibility, seeing how they go about their jobs. It's been a great privilege.
Well, thank you for that. I think there isn't anybody who wouldn't be a little bit starstruck by the Queen. I just finished watching the Netflix series The Crown, which isn't the same, but I just thought, what? That world is just magic to so many of us. The princess and queen world is just amazing. So I think with that, unless there's anything else you would like to say in this part of the podcast, I think we'll call this one done.
Thank you so much for this. It was lovely chatting with you.
Likewise, it was a pleasure. Take care. Bye-bye.
Bye.